will be broadcast via your computer speakers. All participant lines are muted. Note the engagement icons on the left side of your screen. A copy of today's presentation is available in the handout section. To ask a question, enter it in the Q&A box. In the event your slide display lags behind the audio, we recommend signing out of.
Welcome to New Trends in Global Lien Searches and Document Retrievals live webinar that's taking place on Tuesday, November 14, 2023. My name is Aisha Stewart and I will be your moderator. Please note, following today's webinar, there will be a few evaluation questions that I will be sharing with you. Our presenters today are Devlin Fisher, Global Sales Support Manager, and Robert McHugh, Global Sales Support Manager for CT Corp. Without further ado, I would like to hand it over to Robert McHugh. Welcome, Robert.
Thank you. Good afternoon, everyone, and thank you for joining us today for the CLE seminar on new trends in global lien searches and document retrievals. Today, we're going to explore lien searching and document retrievals outside the United States. So if you work in the areas of law involving M&A, private equity, lending, there's a good chance that you've dealt with global lien searches and document retrievals previously. However, I expect that this topic is new to a lot of you with us today, especially the global aspect of it. We see that U.S. attorneys tend to expect other countries to have a very comparable system to our UCC, and for the timelines on document retrievals to be the same as they would expect here. But unfortunately, there's a bit more nuance when you take on this work, and we're going to go over that today. And we're going to show you strategies for excelling in your global lien searches and document retrievals, and really in a larger context to help ensure adequate due diligence for your global projects. But first, we're going to do a few quick introductions. I'm Robert McHugh, Global Sales Support Manager at CT, and I consult with law firm customers in the central and eastern U.S. regions, and I work on transactional managed service projects, so anything from global due diligence to entity formations. And with me today is Devlin Fisher, my colleague. Devlin, would you like to introduce yourself? It looks like we can't hear Devlin right now.
Role as a global sales support manager. Can you hear me now, Rob?
I can hear you now. Go ahead.
Thank you. So just to quickly introduce myself, my name is Devlin Fisher, and like Rob, I'm also a global sales support manager here at CT Corp. And in my role as a global sales support manager, I'm essentially an extra resource for not only our internal sales and service teams, but also our customers anytime they're working on a project that involves a global component. So that's everything from global entity formation to global due diligence to pretty much anything that falls underneath the umbrella of global. Rob?
Thanks, Devlin. So let's look at our agenda for today. First topic is stepping outside the United States. And even if your work's 95% domestic, it's more and more likely that you'll have a global due diligence project land on your desk at some point in the future. So when that situation arises, what should you expect for lien searching or obtaining documents from a foreign country? So we're going to enlighten you with some considerations that you know what to expect with this work. And then we're going to discuss developing an effective global due diligence strategy. And in this portion, we'll look at ways to support a due diligence strategy for your project. And this includes how to determine where to search if there's a foreign debtor involved. And we'll look at other common due diligence searches as well. A lot of times with lien searches, we do litigation and bankruptcy searches in conjunction. So we're going to touch upon those. And then my colleague Devlin is going to take over and go over due diligence in Canada and Mexico, recent updates and new trends. And then finally, he's going to go over a few tips for your next project. So without further ado, let's get started. So at the onset of the project, it's really important to stop and think about some of the items on the screen here. What is the global component to the deal? Is it tangible, movable property? Is it real estate? Maybe it's an M&A transaction. What's really common with M&A is that the target company has a dozen or a few dozen subsidiaries located in the world. And from a due diligence standpoint, this is where things get exciting. Most likely, we want to know something about those subsidiaries, and if they're in any kind of trouble, maybe it's financial difficulty, maybe there's some compliance issues, maybe they missed some filings, and they've fallen out of good standing. What about the assets owned by the subsidiaries? Are there liens against these assets? And if there are liens, then there may have to be a discussion on valuation, especially if those or an unexpected liens or previously undisclosed liens. They weren't expected, but nevertheless, they're there. And that's going to change the dynamics of the deal, and that's significant. Another consideration for M&A is the status of foreign individuals. And these days, the United States and a lot of other countries have sanctions against Russia, Iran, on individuals and companies. And the list tends to get bigger and bigger. So it's crucial to your deal to know whether, say, a shareholder is on an OFAC sanctions list, an Office of Foreign Assets Control under the U.S. Treasury Department. I think everyone here would say, yes, we want to know if that shareholder is on a list somewhere. So that's really crucial. And the overarching theme is that we don't want any surprises for the clients. The goal is to have the client with sufficient information to make an informed business decision. But with any due diligence project, we're always dealing with some level of risk. You'll probably hear us say risk a lot today. And as we work to reduce this risk, the budget will naturally increase. Makes sense. The more work you do, the more it's going to cost. And the goal is to reach an acceptable level of risk in your due diligence while staying within a desired budget and timeline for the project. And it's really a balancing act. And then what's your expertise in the foreign jurisdictions? Clearly, if it's an unfamiliar jurisdiction, it'd be prudent to extend your timelines, your estimated timelines, because you have to account for additional research. And how will you deal with those unexpected delays at the local level? Because a lot of countries, they don't work as smoothly as we have things here in the United States. Fortunately, the pandemic-related delays are over, but it doesn't mean there's reliability everywhere. So that's definitely a consideration. Now, before we dive into global lien searches, it's really important to understand our vantage point here in the United States. So I'm going to touch upon the 5-part search, which is on the left side of your screen. And if you've been in other CT seminars, you've probably seen something almost exactly like this, the 5-part search. So it includes UCC liens, fixture filing liens, non-consensuals, that's the federal tax, state tax, judgment liens, bankruptcy, and pending litigation. So what's a UCC lien? Just start basics. It's a public record showing that a company has borrowed money with collateral, and it is normally filed by the lender against the assets. These are consensual liens and follow the rules of the code. Therefore, it's fairly straightforward when it comes to conducting UCC searches, as long as you have the debtor name and location as the word to search. So those are at the top of our list, UCC lien searches. Then we have federal tax liens. Those are filed by the IRS when taxes are unpaid. There are state and local agencies can also file liens for unpaid taxes. Then we have bankruptcy and pending litigation searches. Now, if we look at the right side of the screen, when we step outside the United States, our goal is to still conduct that 5-part search. But we can't expect foreign countries to have that 5-part search available. It's kind of compare it to getting a burger here. You can get everything on it, but then you might have to have a bland burger if you're stepping outside the United States. It's just not, all the ingredients aren't available. You just have to deal with it. So most likely, you're going to have a lien or what's called a registered charge available. The terminology differs, but these are comparable searches. And most countries have a search that is comparable to the UCC Article 9 search. But then there are plenty of countries that don't. You're also going to likely find a real estate or property lien searches and non-consensual lien searches in non-U.S. jurisdictions. And the big takeaway here is that even though you're accustomed to the 5-part search in the United States, there's a really good chance that you won't be able to conduct a perfect 5-part search outside the United States. It may be a 4-part search, a 3-part search, something like that. So your approach will have to differ based on the country. So what should you expect to encounter? Well, it's really going to depend on the country, like I just said, and your strategy is going to have to adjust accordingly. Some countries have very few searches, and then other countries have plenty of searches. It is very common for global due diligence projects to include lien, litigation, and judgment, and bankruptcy searches. So if you're new to this topic, just keep that in mind. If you're looking at doing due diligence on entities or individuals, look at lien, litigation, judgment, and bankruptcy searches. Then on the document retrieval side, it's common to see that most countries offer some form of good standing certificate. Sometimes the commercial registry extract or company profile serves as this good standing certificate. And most countries offer a way to get copies of the charter documents. So that's the certificate of incorporation and the articles and memorandum of association. So let's go over some concerns when you step outside the United States. Searches and documents go by different names depending where you are. For lien searches, for example, if we're in Canada, those will be the PPSA searches, the Personal Property Security Act searches. And similarly, in Australia, they have the PPSR searches, which are the Personal Property Security Register searches. And if we jump to the UK, the appropriate search would be what's known as a registered charge search. And that concept of a charge can be found throughout the Commonwealth realm and Crown dependencies. Some countries do not have systems like the UCC or the registered charges that we have in the UK, and they're going to rely on private liens or pledges between contracting parties. And if that's the case, just do not expect that you'll be able to search a central registry for liens against a company. That information is just not simply public. So you may be able to find some information on a public gazette. Sometimes pledges or liens are filed there. And sometimes companies they'll voluntarily publish it there. They may be there, they may not be there. And then we encounter the same problem with court records. Some countries consider litigation more of a private matter between parties, and you will not find certain details that you'd expect to find, say, in a U.S. Court search. And with regard to physical presence, do not be surprised if in-person visits to conduct searches or obtain documents are required. Now, obviously, if you run into this, you will have to rely on a service provider. And then translations. 2 quick notes here. If you conduct a search or order a document, just know the language of the document or the search results. And also, if it's a different language and you're going to need translation, get that service ready before you get the results back. There's nothing worse than getting results back from a search or on a document retrieval, getting that document back and scrambling to find a translation service at closure. And then finally, expect longer timelines for your searches and document retrievals. And this is pretty consistent for most global work. It takes a little longer. Believe it or not, things here in the United States are pretty quick. But we should expect a bit of a delay. I won't say delay, but just a longer timeline when we're dealing with global searches. So next, we're going to look at developing a strategy. And we're going to start with a very high-level look at a due diligence strategy. And you can see here there are a lot of factors to consider. And these are the factors that may affect a party's decision to enter into a transaction. If due diligence is done correctly, it's going to expose risks. And the goal is to balance the amount of time and money spent on a transaction while minimizing risk. And so let's look at the what. The type of transaction may drive your strategy. So, for example, we have a client who's acquiring non-U.S. entities. Lien searching will be key to the strategy because any undisclosed or unexpected liens on assets owned by the subsidiaries can be material to the deal. What are the assets involved in the transaction? Because the type of asset may change your lien searching. Countries may have separate legislation for certain asset classes. So think of aircraft, boats, mobile homes, fixtures, and so on. So if you're looking into the laws of that foreign jurisdiction, you may have to consult multiple statutes to figure out what's going on. Concerning who? Will your due diligence look at entities or will it also look at individuals as well? We may want to look at the directors and the individual shareholders for any red flags. Do they have any shady businesses on the side? Are they just doing shady things? We want to know about those. And it's really important we identify any of those red flags. Concerning when, understand how much time you have to conduct due diligence because, there's a big difference between a 5-day window and a 1-month window. And with this work, you really want to know the turnaround times ahead of time so you can plan proper project management so you're not getting results too late in the process. And then be sure to consider the size of the transaction as it will likely play in a budget. If the budget's tight, then you may want to consider limiting lien searches to certain entities. Often there are entities with limited operations. Sometimes they're dormant entities and there's just no real assets owned by them. So the chance for liens against them is very low. So you may opt to focus elsewhere. And let's say we have a foreign debtor. Where do you start your lien searching? Well, the answer is, like many of you know in the legal industry, is that it depends. And getting to the answer isn't really intuitive, but we have a good roadmap. Next 2 slides. So this is going to help you when you're dealing with a foreign debtor, among other things. And I recommend taking notes on this slide in the next one. But also remember these slides. Just one thing I do want to point out is that it's important to understand if the entity has entered into any secure transactions, and we really have to look at where they would be filing or filing that secure transaction, and that's where we kind of start as our basis. Now, under Article 9, the secured party typically files according to the debtor's location for personal property, but dealing with a foreign debtor requires additional analysis and challenges. So first, we look at the Chief Executive Office. Where is it located? And this is for a non-U.S. debtor. Where is that one located? That's our starting point. If it's located in the United States, search in that state. If it's located in a country with a quote-unquote UCC type system, and that system meets the UCC equivalency requirements, you would search there. If the Chief Executive Office is outside the United States and that country does not have a filing system for security interests that satisfies the UCC, then search in DC. So if we have a foreign entity as part of our due diligence, look at that location of the Chief Executive Office. If it's outside the US, then you have to determine if that country has a UCC type system. What is a UCC type system and how do we figure that out? We're going to get to that more in depth in the next slide. But as a caveat, with any due diligence, it's about risk. Just because you know where to search using our UCC doesn't mean you're going to find anything additional by going above and beyond and perhaps conducting additional searches. It's really about achieving your desired level of due diligence and acceptable risk. So the UCC provides a three-part test in 9307C in order to determine whether the home country's filing system is acceptable for filing and thus searching. And the basis of this test is that a non-U.S. debtor normally would be located in a foreign jurisdiction, and as a consequence, foreign law would govern perfection. So let's look at each leg of the test. And the first part requires the home country to have a filing system or a recording system in place. And that's really, this is the easy one, the easy leg here. Is there even a system in place? You can usually figure it out really quickly. The second part asks whether the recording of a security interest is required to establish priority over a lien creditor. And the third part requires whether the information can be generally available. In a lot of countries, that information is not available, or you may need permission to access the information, meaning a country's system would fail this test. I know what many of you are thinking, which countries pass this three-part test? Let's just jump to it. I do want to emphasize that there are many filing systems outside the US. Not all of them would meet this three-part test. And a good rule of thumb is that you can rely on Canada, Australia, and New Zealand as passing the test. You can have a high degree of confidence in your lien searches in Canada, Australia, and New Zealand. But there are a lot of other countries that would pass this test, including Vietnam, Israel, a lot of the former Soviet Union bloc countries. And why would they pass? Why would Eastern European countries pass and other ones wouldn't? Well, it's because their secure transaction laws are newer and they were drafted by legal experts in the United States. But beyond Canada, Australia, New Zealand, it's important to note that research is likely required, and the answer is going to lie in the secure transaction laws of the country. Just remember that statutes change, so a country's filing system and recording system can change too. So one day it may pass the test, and the next day it fails. So just keep that in the back of mind. In practice, it is very, very common for U.S. attorneys to search for liens in a foreign country, even if that system doesn't meet this test, just in case something comes up. This is what 9307C tells us what to do, but there's a good possibility there's something out there that company has, maybe assets in another country. We want to know about it, and it's so we may want to go above and beyond and conduct searches in that country, but it's still important to understand the analysis here under 9307C. So looking at global lien searching, the primary challenge for U.S. attorneys is having to contend with a patchwork of laws that cover lien searches and the lien filings, and achieving an understanding of how liens are treated in these foreign jurisdictions. It's not an easy job. And even though the process by which you would search liens differs country to country, just keep in mind the following concepts. For common law jurisdictions, so those are the ones where there's some connection drawn back to the British Empire, more likely than not, that jurisdiction is going to have a register of charges, and that is where you want to start searching. And keep in mind two things. Public access may require credentials and fees, and two, the filing of a charge or lien may not be mandatory in that jurisdiction. So just take it with a grain of salt if that filing is voluntary and you're doing a search there. And then civil law jurisdictions, they're a different animal. The jurisdiction may be pledge-based and not searchable, as those would be private. And if it's not apparent where or how you search for liens, just check the relevant legislation and try to understand the basics of this security interest filing system. It may be covered under the Companies Act of the jurisdiction, or it could be a standalone piece of legislation like we have with PPSA, the Personal Property Security Act in the Canadian provinces. Does the country have a centralized filing system that allows a single search using the name of the entity, or are liens considered local filings and made at the county or state level in that country? If it's the latter, the more local level, expect that you'll be relying on local service providers, or a U.S. provider to manage that searching. Looking at real property fixture filings under the UCC, this is a UCC concept. We know fixtures, there are goods that have become so related to particular real property that an interest arises in them under real property law. And this is a UCC concept, and it likely doesn't exist in the foreign jurisdictions you're working with. But we do see mortgages, real estate liens, other encumbrances come up in due diligence searches on real property. In most cases, you would want to conduct a real property search, perhaps at the land registry. And then in doing so, you could pull up details on any mortgage or lien on the property. And sometimes, depending on the jurisdiction, the only available information is the ownership details and when that real estate was last transferred. So along the same lines of lien searching, we have litigation and judgment searching. And this is going to be core to your due diligence approach. It's rare to find a project that only looks at liens but not litigation or any judgments. Some countries offer a centralized search of the court system, so it'll pull any litigation or judgments on a company for the whole country. But a lot of countries require searches at different court levels, the very local level to what we call the state level, and then up to like the federal level. So you have to analyze and decide which courts within this country are relevant to my due diligence. And you may opt for searching courts of general jurisdiction, and you may decide it's not worth checking the appellate courts. It's just going to be too much time and too much hassle. Searching every single court is probably not practical, to be honest. It could be a huge undertaking. So what's the best approach? Well, don't waste too much time at the very local level. If you're working on a large M&A deal, most likely you're not going to care about those smaller cases. So the larger the case, the more likely you're going to have a higher court handling it. So it's common to search, say, civil courts that handle commercial cases with damages over $50,000. That's a really good place to start. You know that the damages below, in the smaller courts, the lower courts should be capped under $50,000. So that's a really good place to start is with that one commercial court. Two considerations with litigation and judgment searching. First, the results may not provide much information, like I said before. There may be a judgment against an entity, but that judgment amount is not public, so it only helps you to some extent. And second, you have to know how many years that database goes back in. So it may only cover the last 5 years, it may cover the last 10 years, maybe 15 years. That's information that the client should know, and you should know when you're doing your due diligence. And then you should know whether you need someone to conduct that search in person or whether it can be done electronically. So that's something that's going to play into your timeline and budget as well. Most times when you're conducting lien searches, you're probably doing bankruptcy searches in parallel. And why is that? Well, if there's a bankruptcy, there's probably liens out there. You can expect, I really expect that most people on the call today have some familiarity with Chapter 7 and Chapter 11 bankruptcies. Outside of the United States, it's common to find countries that have comparable laws dealing with liquidations and reorganizations. And you're going to find that insolvency proceedings in other countries tend to be more out of court, and they involve licensed insolvency practitioners. And hopefully, to make things easier, you may find that the country has a centralized insolvency or bankruptcy register that is searchable. And sometimes there's certain courts you have to search to see if there's anything on file. And then sometimes these bankruptcy and insolvency proceedings commence at the local level and don't make it to the federal level until later in the process. So you may have to search in two places. Depending on the country, you may be able to determine the entity status by pulling a certificate of good standing or company profile. It may show as winding up or in liquidation. So that's a bit of a shortcut that sometimes works. But there are a lot of considerations that you have to make, and a lot of them are on your screen right now. What rights are afforded to creditors and third parties. What information is actually available out there on bankruptcies and insolvencies. Now, there are other due diligence searches out there you should be aware of, especially if the country does not offer any type of lien search. How do we ensure adequate due diligence? Well, you have health checks or credit checks as an option. Those are not government reports, but they are useful. Depending on the country, you may be able to pull the financials of the company. Sometimes those companies are required to file those, and you can pull them and get a good sense of financial health. And then there are also intellectual property, IP-related searches and searches on persons. So there's a few options you have if you want to do more searches and go above and beyond. So now, looking at document retrievals. On your screen, we have common documents available at corporate registries. So understand the requirements of your project and figure out what is the actual information you're looking to get on this company or individual, on this individual, on a company. Is it confirming whether the company is in good standing or in liquidation status or in that jurisdiction? Are you looking for the registered address of the entity or the details of the directors? Are you interested in knowing what the company has filed recently? It could be the annual financial statements. Maybe there's a change of directors form or a change of address form that you want to see. Maybe the entity has changed its name, and you may want to know what the former name was because you may want to search for liens in that former name or do judgment searches using that former name. From there, the next step would be to research the available documents at that corporate registry level. Sometimes this is straightforward, and a lot of times corporate registries, they may not have user-friendly platforms, and you're left with a lack of information, or sometimes the information is in a different language and even seems to conflict. And the risk is that you may order a document, it takes, say, 5 business days, and then translation takes a day or two, and you realize that the information you really needed in the beginning isn't on this document. And now you just wasted time and money. So understand the limits of your team and your expertise in that country. If the client inquires about a questionable or unclear result, can your team explain it to them? Can they explain the laws and what the document's actually pulling and the information and the relevance of the information? Finally, if there isn't a central registry, a corporate registry for the entire country, then expect a bit more difficulty. The local ones, the smaller ones, they usually have their own rules, their own processes for things, longer timelines, and they usually don't have, I would say they have more limited electronic access to databases. So sometimes you have electronic access, sometimes you don't. If you don't, then an in-person visit is required. For M&A deals, it's really common to see a need for certificates of good standing. And most M&A deals there's entities, subsidiaries located around the world. So you're pulling a lot of these at one time. And you have to think about whether your team has the capacity and expertise to obtain the right document, the right time, in the right timeline, and without messing up or anything. So is your team able to stay organized? And a lot of times this is more of a question about project management and staying within a timeline and a budget. So it can be challenging, but it's doable. But just be aware of the limitations of your team. So next, my colleague Devlin's going to take over due diligence in Canada and Mexico. Devlin?
Thanks, Rob. And you can hear me, right?
I can hear you, Devlin. You're good.
Thank you. Great. So I would now like to bring your attention to and discuss some of the specific challenges of many of the most common jurisdictions that U.S.-based practitioners encounter when doing global due diligence. Additionally, during this portion of the presentation, we're going to be paying particular attention to the U.S.'s 2 geographic neighbors. That'd be Canada to our north and Mexico to our south. So let's begin by discussing the due diligence options available for Canada. So as it exists, Canada is comprised of 10 provinces, 3 territories, and the federal district. And as Rob said, it is important to know this because each of these political subdivisions are their own separate sovereign and have their own unique legal systems. Knowing where the entities or individuals involved in a deal are located is going to be crucial because it will drive where you'll need to do your due diligence and the types of searches that are available. So let's start off by discussing the most common types of searches that are available in Canada. So the first one we have on the slide are Personal Property Security Act searches, or PPSA searches. Now, although it's not completely equivalent, the PPSA is Canada's equivalent to UCC Article 9 searches. And by far, PPSA searches are the most common type of search that is a component of Canadian due diligence projects. Now, similar to the UCC, there's not uniformity of the PPSA among the provinces and territories of Canada and how each province's system operates. However, throughout all Canada, the PPSA does operate as a searchable all-electronic filing system. Now, similar to the UCC, the main purpose of the PPSA is notification, and a filing is referred to as a registration. So if you're working on a deal involving Canada and you want to confirm if liens against movable property exist, you're going to need to perform some PPSA searches. And I also want to quickly take this time to also mention Canadian Bank Act searches. Now, while the PPSA can be ascribed as the Canadian equivalent to the US's UCC Article 9, bank searches are unique to Canada. The Canadian Bank Act affords a particular type of security that is available only to Canadian chartered banks and foreign bank subsidiaries. Under Section 427 of the Bank Act, these banks are entitled to take security from certain classes of debtors against articles that the debtor deals in, produces, or uses in the course of its business. Now, these liens are filed with the Bank of Canada agent in the province where the debtor has his principal place of business, so that is where the search will have to be performed. Now, these debtor classes include, number 1, manufacturers, number 2, wholesale or retail purchasers, number 3, shippers or dealers, and finally, number 4, farmers, fishers, and forestry producers. So if you're working on a deal and there's a target that could be a debtor as part of one of these classes, you may want to consider including a Bank Act search as part of your due diligence. The next type of search we have on the slide are real property searches. Now in Canada, real property searches are searches of the local or city records regarding a particular piece of real property. Now these are normally used to confirm ownership of that real property and to confirm if any liens are filed against it. Now these liens may be voluntary, and a quick example of voluntary lien would be something like a mortgage, or they can also be involuntary like a mechanic's lien or a tax lien. Now similar to the US, a lien does stay with the property if the property is sold, so the buyer assumes responsibility for the lien even though it was incurred by the previous owner. So if there's a piece of real property that's involved in a deal, you're probably going to want to run some real property searches in Canada. Now, another type of search we have on this slide are Tax Court of Canada searches, which are kind of a misnomer, as Canada doesn't have specific tax lien indexes that are comparable to tax lien indexes in the US. Instead, when taxes are unpaid, the applicable tax authority can obtain a judgment, which may be found in litigation searches, or occasionally notices of unpaid taxes can also be found in PPSA searches. And a further type of Canadian search we have on the slide are judgment or writs of execution searches. Now, throughout most of Canada, judgments are called writs of execution, and they are very much like judgment liens here in the US. Now, these relate to judgments that exist due to previous litigation that entities and individuals may have been involved in. Now, as these can also impact the valuation of a deal, like other types of liens, these are normally run in conjunction with other lien searches. Just to wrap up this slide here, there are also local and federal bankruptcy searches. Now, these are searches that are performed to confirm if an entity or individual has, as you could guess, have ever filed for bankruptcy. And you can run these searches at both the local level and the federal level. Now, one thing I want to point out about the difference between these levels of searches is that although bankruptcies are filed locally in Canada, the final report is only registered with this federal database. So in most cases, the provinces keep the development of bankruptcy files at their local courts before they are ultimately set to the federal database for final publication. Now, as a result, typically both a local and federal bankruptcy search is performed. And another option is civil litigation searches. Now, these are searches performed on entities or individuals to confirm if they are involved in any civil litigation. But once again, location is key. As Rob said, it's not necessarily effective to search every court in Canada to confirm if any civil litigation exists. And finally, the last one we have on the slide are criminal litigation searches. Now, criminal litigation searches are also an important option in most Canadian provinces. Now, typically, criminal searches will show whether or not any criminal cases exist against an entity or individual in the province the search is being run, and also confirm the status or disposition of that case. Now, whether or not an individual or entity involved in a deal has been involved in a criminal matter may be important for your client to know. So if that's a consideration, you may want to run a criminal litigation search. Now, moving on to our next slide here, we've included it as a quick example of some of the provincial and territorial differences in Canada as they relate to the PPSA and how these differences also compare with the US UCC. Now, as this chart is included in the CLE reference materials, we're not going to spend too much time on it, but in summary, this slide is designed to highlight that the UCC and the PPSA are not identical systems to one another. This slide also highlights why it's important to know what Canadian province or territory the entities, individuals, or assets in a deal are located, because due to these differences, the legal rights of lien holders, creditors, secured parties, and really any other groups may vary depending upon which Canadian province or territory is involved. So now let's proceed to discussing Mexico. And just to set some expectations here, Mexico notoriously does have slow turnaround times. So if Mexico is a component to your deal, you're going to need to take into account the slow turnaround time and set expectations accordingly. Now, as to performing due diligence, Mexico's secured financing laws are significantly more complex than the UCC in the US. As a preliminary caveat, it's important to note that there is no central registry in Mexico to search for liens filed against the company's real property or assets, in the sense that the RUG, which we're going to discuss here momentarily, is not the only option to file liens. So with that in mind, where do we search for liens? Well, the first place we search for liens in Mexico is with the RUG, the Registro Único de Garantías, which is actually pronounced RUG. I know the acronym is RUG, and you might want to pronounce it RUG, but it's actually pronounced RUG. And the RUG is a national electronic database for the recording of liens in Mexico. Now, although it's relatively new, a lot of people and companies do use the RUG filing system, as it's generally less costly to file than a public registry filing. And for this reason, we do not see many Mexican state-level filings anymore, as most companies prefer to use the RUG, so that is where most due diligence projects start their lien searches. Now, however, the RUG still is not considered mainstream enough to be comprehensive, and as such, should not be immediately the only place to search. Now, the second option being for liens is the Public Registry of Commerce. And this will actually depend upon whether the specific Mexican state registry that's involved will still allow it. This is historically where most liens on movable property were filed before the introduction of the RUG. And the reason why a lien filed with the public registry is more expensive is because the notarial deed for the lien will need to be drafted and accompany the filing. Now, to perform a search, you'll need to know the specific Mexican state where the company is registered, as well as its folio mercantile number, and that's where you'll search. Now, the specifics of your individual deal will drive your determination as to whether you need to search the RUG, the state registries, or both. It's also important to mention that there could also be private agreements between companies, between lender and borrower, which are not filed in any of the publicly available sources, but which nevertheless may still have legal rights. As such, there's always this possibility of a wild card lien existing in Mexico. Now, some other common due diligence options here real quick that we see in Mexican due diligence projects are also similar to the US and Canada: criminal and civil litigation searches, and real property lien searches as well. And your options will vary based upon which Mexican state and what the location is that you're doing your due diligence. But now we'll move on, and we'll quickly take the opportunity to discuss some high-level considerations when conducting due diligence in a few other common global jurisdictions that are often a component of global deals. Now, the first three we have on this slide here from left to right are Australia, China, and the United Kingdom. So to begin with, Australia. In Australia, liens are filed with the PPSR, or the Personal Property Security Register, and obtaining corporate documents is relatively easy. Now, search results and documents are in English, so translations are not normally a consideration. Now, it's important to note that the PPSR does satisfy, as Rob said, UCC Section 9307, so you can have a high degree of confidence in performing lien searches there. Now, the next jurisdiction we have on this slide is China. And China really is a notoriously difficult jurisdiction to do due diligence in, and the options you might be familiar with in other global jurisdictions don't really exist. Now, there are no true lien search options available in China, although corporate details may be obtained by ordering registry extracts and similar types of documents. Now, these documents will likely be in Chinese characters, so if you need translations, set appropriate timelines. And the last jurisdiction we have on this slide is the United Kingdom. Now, in the UK, liens may be found by performing a registered charge search, as Rob mentioned earlier. Now, the corporate registry in the UK, which is known as the UK Companies House, is very responsive and typically easy to work with. But as a quick note, there are some distinctions in certain types of searches like bankruptcy when it comes to where the entity is registered, whether that's England and Wales, Scotland, or Northern Ireland. So you always want to be sure you know where your target is located so you know where to search. So we're now going to move on to 3 additional jurisdictions. And on this next slide, we have Brazil, the Cayman Islands, and Singapore. So start off with Brazil. Now, similar to Canada and Mexico, each Brazilian state, and there's actually 26 of them, and the federal district, they each have their own company register, and each have the authority to implement their own policies and procedures, and each offer their own types of corporate documents. Now, although almost all Brazilian company registers have a website that can be used to obtain some company information, not all these are public, and not all are searchable. Additionally, almost all these websites are in Portuguese, and many of the documents and search results that you can obtain will also be issued in Portuguese. So if translations are needed, you should account for additional time in your due diligence timeline to arrange for those translations. And the final jurisdiction, or rather the next jurisdiction we have here, is the Cayman Islands. And the Cayman Islands is a common jurisdiction for fund, holding company, and SPAC creation. However, the Caymans also tends to be one of the most logistically difficult jurisdictions to confirm lien information and to obtain copies of corporate documents due to the jurisdiction's preference of privacy over transparency in corporate affairs. Now, in many cases, only the registered agent of a Cayman entity can confirm most lien information and obtain copies of corporate documents. And these would be things like certificates of good standing or charter documents. Now, as a result, in the initial stages of doing a due diligence project for a Cayman entity, you should identify who the registered agent is and make note of their contact details. And the reason why I say this is because if you need this information, it can only be obtained from the registered agent. So you're going to need to contact them to get that type of information. And finally, the last jurisdiction we have on this slide is Singapore. And Singapore really is a common Asia-Pac jurisdiction for global organizations. In our experience, the governmental agencies that regulate companies there are very efficient, responsive, and helpful when we work with them. Now, similar to the Caymans and several other jurisdictions, the role of company secretary is a statutory position that is required to be appointed to each company. Now, just like in the Caymans, in the initial stages of doing due diligence for a Singaporean entity, you should identify who the company secretary is. And the reason why I say this is because as of recent, certain corporate documents and searches, like obtaining certified copies or certificates of incorporation, and even performing tax checks, can only be obtained or performed by one of the company's officers. So third parties can't get these. So in most cases, the company secretary will be the easiest person who can get these for you. So we're now going to move on and discuss some recent updates and some new trends that we're seeing in the area of global due diligence. So one of the hottest topics in global due diligence and global lien work is how local jurisdictional systems that regulate the creation of security interests over assets, how they treat cryptocurrencies when they're being used as collateral for debt. And this is really understandable as there are well over 20,000 different cryptocurrencies in existence with a total market capitalization of over $1 trillion US. And their acceptance as use for payment or collateral has been higher than ever. Now, as some of you may have heard, the treatment of cryptocurrencies by different jurisdictions has really been all over the map. You know, some jurisdictions like El Salvador in 2021 and the Central African Republic in 2022 have actually gone so far as to adopt Bitcoin as legal tender. Now, on the other hand, jurisdictions like China, Nepal, Bangladesh, Afghanistan, and Egypt have all banned the ownership and use of cryptocurrencies. Now, for those jurisdictions where cryptocurrencies are legal, governmental authorities have variously classified cryptos in different contexts as assets, as property, commodities, securities, currencies, and even other classifications. And it's important to note that each of these terms may have a specific or a different meaning or definition in each jurisdiction that's involved. And depending upon what the specific classification is in a particular jurisdiction will drive the way liens are created over cryptos and the respective rights of the parties involved. In addition, many central banks have also implemented or explored the creation of what's known as central bank digital currencies, or CBDCs, which goes to further obscure the categorization of different types of cryptocurrencies. But in any event, it's important to understand that there is no single set of rules or processes across all jurisdictions regarding the use of cryptocurrencies as they relate to liens. Moreover, as this area of work is still new, we can expect that jurisdictions will change their treatment of cryptocurrencies as time goes on. Now, while we don't have time to go over how every jurisdiction treats cryptos in relation to lien creation and enforcement, we do want to quickly discuss how the Canadian PPSA treats these. So to start, let's take a look at the US UCC and how the UCC treats cryptos. Now, in the United States, recent amendments to the Uniform Commercial Code were adopted and recommended for enactment by the Uniform Law Commission in July of 2022. Now, new UCC Article 12 includes rules for transactions involving a new category of assets that are referred to as controllable electronic records, or CERs, which include cryptocurrencies and also NFTs, or non-fungible tokens. Now, per new UCC Article 12, a CER is defined simply as a record stored in an electronic medium that can be subjected to control under Section 12-105. Additionally, amendments to definitions in UCC Article 1 and also UCC Article 9 will create rules concerning security interests in CERs as well as in CBDCs. So far, these new amendments to the UCC have been enacted by at least 9 states and introduced in more than 20 others. And it's important to take note of how the U.S. is treating cryptocurrencies, as many foreign jurisdictions have looked to the success of the UCC when creating their own systems for the creation of security interests, most notably Canada. Now, it's anticipated that many foreign jurisdictions may decide to take the same approach to cryptocurrencies as the U.S. ultimately does. And just as a side note here real quick, if you are interested in these recent changes to the UCC related to cryptocurrencies, we do offer other CLEs that are specifically on these topics. So if that's something that interests you, please feel free to reach out to a CT representative and they can schedule a training on these topics for you. Now, as it relates to Canada, similar to the US UCC, the Canadian PPSA is a set of laws which govern, amongst other things, the creation and regulation of security interests over personal or movable property. Now, like the US UCC, the underlying enabling laws for the PPSA have been passed on a provincial or territorial level, which has created some differences across Canada. Now, cryptocurrencies as an asset class are not currently explicitly addressed in the Canadian PPSAs. But given the status of certain cryptocurrencies and their characteristics, many scholars have noted that they would likely fall under one of 2 different PPSA asset classes. Now, the first class would be money. The PPSA defines money as a medium of exchange authorized or adopted by the Parliament of Canada as part of the currency of Canada or by a foreign government as part of its currency. So with El Salvador and the Central African Republic recently declaring Bitcoin to be legal tender, it is arguable that at least Bitcoin could fall under the money asset class for the PPSA, and the rules regarding registration and perfection of money assets could be followed. Now, the second asset category we have here is intangibles. And intangibles are defined by the PPSA as all personal property that is not goods, chattel paper, documents of title, instruments, money, or investment property, including choses in action. Now, as a result, and given that cryptocurrencies do not seem to fall into one of these categories mentioned, it's arguable that the rules related to lien creation and perfection should follow the rules related to intangibles when it comes to cryptos. Now, regardless of whether the Canadian courts ultimately choose to enforce security interest over cryptocurrencies under a theory of them being a money asset, an intangible asset, or some other asset category, or even if the provinces or territories implement amendments to the PPSAs to specifically address cryptos, similar to the UCC, it's important to note that you need to understand that this is very much a new and evolving area of practice in the area of liens. Now, as time goes on, in Canada and other jurisdictions regulate cryptocurrency through legislation, we'll be able to get a better picture of how best to protect the rights of the parties in relation to a transaction that involves cryptocurrency. But for the time being, if you're working on a global deal involving cryptocurrencies, just be sure to understand the current status of how the specific jurisdiction you're working in treats them and what the rights of your clients are in relation to them. Now, moving on to our next slide here, there is one interesting topic that I would like to bring your attention to, and we're actually following it because it is interesting, and it's the ongoing negotiations regarding the draft UN Cybercrime Treaty. Now, under Article 93 of the draft treaty, it would require a state party, that's a jurisdiction participating in the treaty, and now this is a mouthful, so listen here. It would require it to take all necessary measures enabling it, in accordance with its domestic law, to obtain from financial institutions and from organizations engaged in activities related to the circulation of digital financial assets and digital currency operating within its jurisdiction, information on the identity of customers and beneficial owners. So while the U.S. Corporate Transparency Act, or the CTA, is a hot topic here in the United States, as it will require many legal entities to report beneficial ownership information to the U.S. federal government, through this treaty, we're already seeing the groundwork being laid between major countries to extend beneficial ownership reporting requirements to the cryptocurrency world. Now, this is certainly a topic we need to keep a close eye on. It's still in its infancy. There are a lot of different organizations and companies that are kind of very vocal on their position on this treaty, Microsoft being one of them. So if you would, search UN Cybercrime Treaty, Microsoft, you'll see a lot of articles on it. But just as a quick note, this idea of ultimate beneficial ownership reporting is being extended, or is in the process of being extended, to other areas, including cryptocurrencies. And I would like to also point out that we do offer a detailed presentation on the U.S. Corporate Transparency Act, which is coming up here very soon. So if this is a topic that you'd like to learn more about, please reach out to one of our CT reps to schedule a presentation. Now we're going to move on to this next slide here, and we're going to take the time to quickly discuss some new trends that we've been seeing in the area of global due diligence. So we're seeing more comprehensive due diligence. More organizations are performing more thorough and comprehensive due diligence on global entities, and this is especially on the buyer side. Parties want to know exactly what risks and liabilities exist before they acquire entities and assets, and they want to know whether there are any remediation remedies available to cure. No one really likes a surprise post-close. Additionally, given the recent market conditions over the past few quarters, we have seen an overall reduction in the number of deals being closed. With higher interest rates, although they've recently dropped a little bit, there's less refinancing of existing debt and less new deals are being financed with debt. Moreover, with an uncertain economic future and the Fed over the past year rising interest rates to cool off high inflation, we are seeing less overall demand, which has caused a rise in the number of bankruptcies being filed, and more global businesses are restructuring their organizational structures so that they operate as optimally as possible given the jurisdictions they operate in. Now we're going to move on to one of our last section for today, and we're going to discuss some tips and tricks for your next global due diligence project. And we want to leave you today with some tricks, or at least something you can take with you for your next project. So from the perspective of before you start the due diligence, once again, consider the transaction. Who are you representing in this deal? What are their acceptable level of risks? What is involved? Is it entities, individuals, intellectual property? Is it something else? Because knowing, identifying, and understanding these things will go a long way in allowing you to effectively create a global due diligence strategy. And you want to proactively collect the data. Any relevant information, and in some cases, even information you may initially believe is irrelevant, should be collected and stored in an easily accessible place. Once you get into the due diligence, it'll be helpful to refer this information so you can adapt your strategy accordingly. And you want to determine the scope, what jurisdictions are involved, what initial searches will you run. Additionally, if something is found, will you then dive a little deeper and do more due diligence? Or are you on a strict budget? And while we're on that theme of budgets, you also want to consider your limits. As Rob said, is time or budget a driving factor that is important to the deal or client? Is this work you can even do in terms of expertise, time, and manpower? Maybe you are really great at this work and have no limitations, but generally speaking, most people are not. And this is not to say that's a bad thing. It's just reality, and we have to be aware of it and know what is possible and strategize based upon that. Another thing I do want to mention here are outsourcing considerations. If your limits prevent you from doing full due diligence on your own, it may not be a bad idea to consider outsourcing so you can get the support you need to effectively assist your clients. Now that you're working on your global due diligence project, you want to continue to collect the data and search results and keep that information in the same place as the preliminary data you already collected. And organization is key. Data is not very useful if you cannot find it. Now, as the search results come back, you want to analyze that preliminary data and add or subtract searches as needed, because adjusting your strategy as you do your due diligence will help ensure that the due diligence is both thorough and cost effective. And you also want to manage your project effectively and efficiently. You want to track your data and results using technology. Are you using file folders, spreadsheets? Are you using some other project management software? The point here is if there's a tool out there that can help you do this work more efficiently, then you should utilize that tool. And parallel focus is critical. You should be negotiating the terms of the deal simultaneously with your due diligence project. Oftentimes issues are discovered during due diligence that can significantly impact the valuation of the deal. Rather than completing these two tasks separately, you should conduct them in parallel, because you really don't want to get to the point where the parties have already agreed to price and structure terms, only then to begin the due diligence work and discover that you have to go back to the deal table and renegotiate the price or structure. Okay, now after your global due diligence project has concluded, you want to consolidate the data and results into a due diligence report that will be easily understandable to your client and any other colleagues working on the deal. If you're the only person who can understand the report, then it's not very useful, is it? Now, based upon the information and data found, you'll then want to do a final analysis and make recommendations to your client. In any deal, there will always be risks present. And it's really your job to make sure your client understands what those risks are and makes an informed decision based on them. But at this point in the project, an underlying question that you should always ask is, was the due diligence sufficient to identify the risks for the underlying deal? If these are things that you're thinking about, you should really discuss these thoughts with your client. If something makes you feel uncomfortable about the deal, then you should convey that to your client. They will listen to you. And you finally want to discuss your conclusions with your client and advise them accordingly. We as legal professionals are in a unique position as our clients do look to us for help and guidance as they work through their deals. And in most cases, they will listen to what you have to say. Do not ever be afraid of discussing some aspect of a deal with your client. So thanks once again for taking the time to join us today. I hope you're able to take something away from this presentation that you can use for your next global due diligence project. I'm now going to hand this presentation back to my colleague, Aisha Stewart, who will be assisting with the polling questions and any housekeeping-related matters. Aisha?
Thank you, Devlin, and thank you, Robert, for presenting today. Before we conclude, I would like to go over a few evaluation questions. The first one is, please rate the value of today's webinar content on a scale from 1 to 5, where 5 is the highest and 1 is the lowest. Again, that is, please rate the value of today's webinar content on a scale from 1 to 5, where 5 is the highest and 1 is the lowest. Moving on to the second question. Please rate today's presenters on a scale of 1 to 5, where 5 is the highest and 1 is the lowest. Again, that is, please rate today's presenters on a scale of 1 to 5, where 5 is the highest and 1 is the lowest. And moving on to our third question. Please rate today's written materials on a scale of 1 to 5, where 5 is the highest and 1 is the lowest. Again, that is, please rate today's written materials on a scale of 1 to 5, where 5 is the highest and 1 is the lowest. And moving on to our final evaluation question. Please rate today's webinar technology on a scale from 1 to 5, where 5 is the highest and 1 is the lowest. Again, that is, please rate today's webinar technology on a scale from 1 to 5, where 5 is the highest and 1 is the lowest. Thank you for joining. This concludes today's live webinar. You may now disconnect.